What's going on? Today is August 9th, 2023, and today I want to share some red flags when it comes to about employment-based cases. Folks, welcome to greencardguys.tv. I'm your host, John Ting. I practice law in all 50 states of America and across the world, helping you solve your immigration problem, maybe even prevent it from happening in the first place. Welcome to the show. If you're just some housekeeping items, if you have any questions, you're welcome to drop it in the comment section down below, and I will try my best to answer it during the show. So it's going to last on LinkedIn. We're going to be on for at least 10-15 minutes, but in general, I'll try to stay on until 12:30 Central Time. All right. And the other thing is, if I'm not able to answer your question, please know I'm trying my best. But at the same time, even if you need a more detailed answer, a more in-depth answer solution, give us a call. All right. Here's our phone number, 720-740-4247. I know I sound like a telemarketer, but apparently I'm not allowed to share it any other way as a comment or something, or on the video. So at least on TikTok. So the first thing to know, okay, this actually came up recently. Now I say employment-based, but there's several different limited, but several visa types. If you own your own company, or if you are employee of a company and you're abroad, right? And most of your experience is abroad outside America, and you're wanting to come to the United States with a work visa, and you already work with that company, just maybe you're expanding an office, expanding the company in general in America. Doesn't matter which state it is. Could be Alaska, could be Hawaii. But the point is, it's kind of like, think about it like a bank. All right. If you think of a bank, there's so many branches, right? It could be a subsidiary, affiliate, USCIS. The law is very expansive in that way. The company in America could be the one that's what you call the subsidiary or the principal company. But the thing is, what we call it is L visa. It's transferring an employee from abroad to an office in the United States. So we do have a lot of co-founders, founders of their own company, and they have no idea what they're doing. They think just because, and it's not a bad thing. It's just common, we wear a lot of hats. I'm the owner of my own law firm. We wear a lot of hats. So I've learned through the years to delegate and delegate more. It's just not just about law firm, but any kind of business that you own, and you're solo, you own your own company, you just tend to wear a lot of hats. So you got to learn how to delegate. So with that being said, which is the general mindset of a business owner, they just think that simply by the fact of owning your own company or co-founding with someone else, that I should get the L visa, and I'm transferring to America. No, that's not the case. In fact, someone that just signed up a couple weeks ago that we're helping out, and it's really about, there's three main options here. You get transferred to America as an executive or a manager or someone with specialized knowledge. So for example, maybe that person is an engineer. Doesn't necessarily have to be specialized knowledge because of your degree or whatnot, but that's a common way to think about it. But this person, in their documentation, when they filed the first time, they mentioned both terms, both titles, executive, and another document had manager. So you really just have to pick one. And here's a key difference, is that executive, and just my quick summary here, is that executive is more about someone who's making a strategic decision. All right. They're not in the nitty gritty of doing the day-to-day work per se of another employee. Whereas, and even executive, you have direct reports, or you have, reports underneath you, right? But you wouldn't have it above you. So if you're in a manager position, above you in an organizational chart, you would have an executive above you, or a VP, for example, or, SVP. There's so many different titles, but you normally, this visa is for big companies, corporations, or entrepreneur, smaller company. All right. So it's not just for one, like you don't have to be Fortune 500 only just to have this visa type to be available. All right. To bring an executive or manager or one with specialized knowledge to America. Now, so that's one thing you need to know, because a lot of people, we've received calls about this, like, and they don't even realize why they were denied. right? So that's why people schedule a strategy session with us. So this is a great opportunity to actually mention with you that we do offer strategy session. Just point you in the right direction, even if you don't hire us. It's okay. We just want to make sure it allows us to fulfill our mission. So the best way to access that, it's not guaranteed for everyone. Okay, it's really not guaranteed for anyone because we do get a lot of requests. But the first thing you need to do, if you're a little shy and you don't want to call in yet, that's okay. Go to our website, greencardguys.com, click on contact us, and it gives you a couple options, but most people pick option number one is to take a quiz to see if you qualify for a consultation at no cost to you. That's for 15 minutes. Of course, if you want more time, which is understandable, to pick option two, I believe. I think it's like 30 minutes minimum. So that kind of gives you an idea. All right, so I see some comments and questions, so I will get to that soon. So that's the one thing I want to mention with you because, I feel bad that that person had paid premium processing and then got a decision that was denied. And even if that person had picked executive or manager, it's very clear that that person was confused, right? Because most co-founders, especially entrepreneur, started their own business, solopreneur, you typically don't think about the difference because you do everything, right? So it's really delegating and really think about like who you're going to delegate, what type of position you're going to delegate certain functions. And that's how you have to think about in terms of organizing your company when you're trying to come to America for this visa. Now, if you're an employer, you're in the HR department, and you're considering a sponsor for next year's registration for H-1B in March, you really want to know when they're going to graduate. And I want to share a debunk a myth per se, I guess you could say, is that the person does not have to have graduated already, because the registration is in March. So the next one will be March 2024. Okay, usually it's the first 2 weeks of March, and then you find out if your candidate was selected. Now, the person can be working for you right now or at that time through something called OPT after they graduated, but there are opportunities for people to, let's say they're the last year of their program, senior year, and they graduate in May. That's okay, because end of June is the deadline to file the H-1B work visa application, the package. So it's kind of like basically a two-step process that we break it down into. So yeah, just let y'all know if you're in the HR or you have your own business, that it doesn't have to be someone that's already graduated, that degree in hand. Okay. There's a lot of red flags that can come up, things that you need to know to avoid. Have a smooth process for your application. And also for the folks that are looking to, change companies, whatnot, if you're wondering when you can start working for the other company, you can't just do it anytime you want. You have to have received the receipt notice before you start working for the new company. So if you're trying to get the timing right when you're jumping ship to another company, that's something to consider. So it's not necessary. If you already have H-1B, it's not necessary to do a premium processing, because the only reason to do premium processing when you already have H-1B and you're changing employer is if you just want to be secured in knowing that you got approved, right? Because just because you filed it doesn't mean you're going to get automatic approval. Just because you already have H-1B doesn't mean you're going to get automatic approval for change of employer application, which, for example, we help with a specific like a dentist before, and even though they were already approved through us for the initial H-1B and they changed employer, unfortunately, the USCIS wanted to send us a request for evidence. And when they sent us a request for evidence, basically saying, does dentist qualify for specialty occupation? We're like, holy hell, this is ridiculous. Like, of course. But they just want us to explain it. They're just giving us a mental exercise, which is fine. That's part of our job. Happy to do it. But definitely had to fight back on that one. All right. So anyway, just things you need to know. I just shared a couple of different examples. By the way, if you are HR or a company, or you have been registered for H-1B March this year, USCIS just released, I believe last week, about the second round. Okay, I know some people have asked me on YouTube and different social media platforms if a second round was coming. I didn't think so, but it happened, right? And I think the main reason, unfortunately, is because some people, beneficiaries, the foreign national was registered more than once through different companies. So I think USCIS is trying to crack down on that. But just so I'll know, if you were, so you need to check if you did register the first time in March 2023, you definitely want to speak with that law firm again, because really, I don't think you would have access to it. Not even the company. The company should, but they're assuming they're busy. You need to check with that law firm that helped you with that. Okay. All right. So I'm going to hop off LinkedIn for now. Let's see. I think I'm doing this correctly. Okay. So in the meantime, for y'all folks that are on, I'm ready to answer questions. See a lot of great questions. Anu, I'm assuming you're asking for a friend or someone you know. Wait time for green card EB3, unskilled worker or other workers. Yeah, I mean, the processing time is about the same for other EB, 2 or 3. I mean, other than your country of nationality, that's a whole nother ball game in terms of that. But in general, average 2 years for all the mini steps, milestones. Okay, other than the waiting for the visa itself, the visa bulletin. Alrighty. Anu, yes, but only GC can employee may. What happens, sir, after you become citizen? So I would need the full story. I don't understand your question fully, because I don't know how that's related to you becoming a citizen. All right, Emily, I'm going to finish up a couple questions on YouTube, then I'll switch to TikTok. Thanks for all the questions. Happy to help. Hello, this question is for education purpose. Okay, for your knowledge base, would I recommend a person that is a green card holder petitioning for spouse and child F2A, but a couple years from becoming a U.S. citizen? Should they file 2 I-130s, one with wife and children, another for the children? Okay, so yeah, I think I had this question yesterday, actually, is that a U.S. citizen sponsor asked me if they had to file separate petitions. Yes. So as a green card holder, you file only one petition. Okay. But yeah, if you become a citizen, if that spouse becomes a citizen, then interesting. Then yeah, you would upgrade that, but then it becomes citizen, then you have to refile a new petition. From my understanding, because otherwise, yeah, F2A. The thing though is that, I mean, even if it shows current, the key thing is if the spouse the foreign national spouse and children are in the United States, you have to show that that person maintains status, because I think this month, August, visa bulletin shows current for, let me see real quick. All right, let's check this out. Okay. Oh, actually, September bulletin is out. All right. No, it's not current anymore. So, yeah, it shows September 2023, but it was current, I think, last month. So, okay. So, anyways, I don't know if that answers the question. Hopefully, it gives you some guidance on that respect. But it just depends when they want to file, I guess. Let's see. At the end of the day, actually not so much when you want to file. It depends if the spouse is in America or not. If in America they likely overstayed a visa, then I mean, you can file a petition, but it's not a huge benefit to file now, because let's say it's able to be processed, it's current, people file 485, they get denied because you got to maintain status. But when the spouse becomes a citizen, then you can waive the unlawful presence. So do you get much benefit filing as a resident holder now and your family's in America? I can't see one right now. I mean, if you just wanted something in the system, sure, but Um, you asked because this person becomes a U.S. citizen before the green card is issued, given the child would be removed from the other one. Yeah, I don't know. That just depends on their personal preference, but I would say not necessary to file now. All right, life with Miss Brown. Can a retired spouse sponsor you using a paid off house as an affidavit? Yeah, you can use it as an asset if the income is, yes, the spouse retired. But when it's a spouse, it's 3 times the difference of a shortfall, the difference of the poverty guidelines they use. So if you just Google search, you might know this already, but just 864p, then it'll pop up the chart essentially. So hopefully that helps, Life with Miss Brown. But you can always check out my other YouTube video about affidavit support or problems related to it. Okay, so check that out. Okay, so yeah, no income, then it's 3 times the difference if it's a spouse case. If it's not a family member who's a spouse, like let's say brother sister, it's 5x the difference. So even if no income, maybe Social Security income, then the difference of that. Hopefully. Hey, Chiku, congratulations! Awesome, glad you got the green card. I know you've been commenting on our channel for the last year or so, so congratulations. Glad you got it. Hopefully you're in the US already. All right. thanks for sharing that. Good news. All right, all right. Well, by the way, Chico, now that you got the green card, hopefully any of the information we shared was helpful to you to some extent. If it was, please go to reviewtinglaw.com. We greatly appreciate any positive feedback, or even if it's bad feedback, we're happy to have it. All right. Always want to. Okay. Now the TikTok. Kai, you recently naturalized. Can you petition your parents and spouse simultaneously or no? Yes, you can. It's just about, on the 864 form, it does ask if you've sponsored other people, or then it's not so specific. I don't believe that say like in the process of sponsoring or not, just like if basically filled out the form for that person or not. So you just might as well just be truthful for it. So hopefully your income is above the guidelines on that sense. Okay. Let's see. Your process time said 2 months. Is it accurate for I-130? Yeah, so I know that USCIS has updated something internally, and they claim to update people accurately. I honestly don't know how they can be accurate about that. Suddenly, like somehow they just had technology that can do that. So everyone that has messaged me about that, like my USCIS account, it hasn't been accurate for them. So yeah, just don't get, to be honest, just don't get frustrated about that, because it's likely going to be off for you. It's just not like if you just filed your application, it's probably going to be rare that it's going to be approved in 2 months if it's a petition only. If it's a spouse case and the spouse is in the United States, the foreign national in the United States, the 2023 trend is 3 to 5 months. That's not for everyone. And that's with interview waived. We believe, with us at least, that we have a proven checklist. It's not just the one that's on the USCIS website. All right, Angel, your mom just got deported to Mexico. What can you do to prevent that? Well, it's too late to prevent if you're saying she's in Mexico. I tried to answer your question yesterday, but basically, even though order removed, she doesn't actually have to wait the full 10 years. But are you a U.S. citizen, Angel, or Angel? Then you can file a petition, and when it gets to the point of visa interview, she would need to file the I-212 in the 601. Okay, most likely 601. All right, so even though it's 10 years bar restriction, you can file those other applications to reduce the timing, essentially. Okay, trending. How long would it take for advanced parole and VAWA these days? To be honest, I have no idea. I don't check the difference in that one for I-131. And just in general, I would say 2 to 4 months. We did have one where their freaking USCIS was ridiculous. They said they mailed it. They don't provide tracking number. So just keep that in mind, red flag. If you're going to move, make sure you update them as soon as possible. You can do that online. Just Google search USCIS AR11. Okay, so, but yeah, 1 to 5 months on average which just doesn't sound like an average, I know, but that's a range. Reggie, I don't know. Maybe that's wrong. Who's next? Okay. By the way, folks, if you appreciate the way we share information, answer questions, tap the screen on TikTok. I think that's the way. Tap it. Give us a couple taps on YouTube, Facebook. Click on the thumbs up. We greatly appreciate it. My marketing team tells me it goes a long way to share our channel to others. And for me personally, I try to go live every day, Monday through Friday, not on the weekends, because then my family wants some time with them. So, by the way, just a personal note, I'm going to start working out today again. It's been a long time. With 2 little kids, it's been tough. So keep me accountable, folks. If you go work out yourself, keep me accountable. All right. Can you get advanced parole under C-14 for U visa as well, DACA holder? Yes, you can apply for advanced parole, at least for DACA, but it's very restrictive. Okay, you can't. It's not like basically it's very restrictive. Like if you have a work conference for your job, or a family member is sick, it doesn't. And we've also used the reasoning of you're visiting a memorial, so the family member passed away already. Doesn't have to be necessarily that the person's alive, actually. So humanitarian reason, they have use a broad category. All right, but if you just look into for tourism purposes, no, that's not going to work for DACA. Okay, Anu on YouTube. You were just wondering for one of your relatives to get faster help for visa. Yeah, I mean, yeah, B1, B2 is possible. B1, B2 is possible for domestic made in that sense, but yeah, there's just way more restrictions. But it's less timing, of course, processing time. But yeah, there's a lot more information we can share with that. Okay, Chuba Elvis. Family adoption. U.S. is asking for proof of 2 years of staying. Yeah, that is annoying. I hate that rule myself. 2 years of staying together, but kids overseas. So that's why it has to be. I think I believe that requirement comes up when you file I-130. So then you likely file the wrong application. You have to file another application related specific to adoption. Okay. And so you might be able to bypass the requirement because of course you're not. And so essentially the first question is that country of nationality part of the Hague? Is a Hague identified country part of the Hague Treaty or not? Because it's two different processes. So we would use I-130 when the person is in America somehow. Already gone through the process, like the actual adoption process. All right, so hopefully it helps. But that's one of those situations you definitely need to speak with a lawyer. Can I apply for EB1 with 75 citations and double masters? It's possible. There's a lot more questions we would have, but yeah, it's possible. Double masters by itself, I don't think just having more than one degree necessarily is enough, but it has to be relevant to your occupation, essentially, of course. Okay, Kimberly, you just got approved for Medicaid. You're a green card holder. Is that not a public charge for you? If you're already a green card holder, then I don't believe it's going to come up again. I could be wrong, but if it's a determination on public charge, that would come up when you go for your interview for adjustment of status. Okay. So keep in mind, even though the 45 application, if you're filing now, there's a question on there that just hopped in there several months ago about, are you subject to public charge? Anyone who's filing based on marriage is subject to the public charge and admissibility rule, just like the health ground rule, even though you took COVID vaccine, or maybe you didn't. But being subject to the public charge rule doesn't mean that you're actually found a public charge, if that makes the key difference there. Because the language does make it a little bit confusing. But if you're already a green card holder, right, I don't recall it being public charge being a question that come up in naturalization, because inadmissibility would be when you obtain residency. So hopefully that helps. What happened if they reject your application because of payment? Then you just refile it with the proper payment. Okay. So you can actually use the form. If you all love about credit card points, you can use G1450 credit, basically electronic payment form. But yeah, but either way, you want to make sure you provide the correct payment. Okay. Which is actually on the USCIS website. Now, if you're filing for residency based on marriage, and I think, what is it? You're between 13 and 75 years old, then it's 1760. Okay. But who knows what else you applied for. Okay. On TikTok, you are message to the world. You ask, quick question. Everyone's question is quick. It's more about the answer. Typically, my answer is not quick. If you submit everything for AOS, medical, A64, everything, you receive combo. I guess you mean combo card. Based on marriage, when I contacted USCIS, they said transfer to field office. What are my thoughts about that? If it's actually like you wouldn't. So thank you for your question. When it's moved from like a service center to a field office, just so for everyone's knowledge, you wouldn't actually receive a transfer notice. Transfer notice. So I'm not really answering your question directly yet. But transfer notice would occur like recently for 601A waiver applications when it's moving from one service center to another. But to answer your question directly, message to the world, if it's your local field office, then it's likely like near where you live. Let's say like you live in Dallas, Texas, and you live in a suburb above that or around it, then I'm thinking it's going to be scheduled for interview. Okay. Because likely if it's going to be waived for interview, it wouldn't even reach the field office. Okay. That'll kind of defeat the purpose of waiving the interview. So hopefully that helps. Okay. Good luck to you. And just because you get scheduled for an interview is not a bad thing. Okay. There could be some kind of hiccup they're looking for. They want to clarify. That's not a bad thing. Okay. It's only in 2023 that we're having this trend of having cases waived, interview waived. So we have plenty of approvals before when there was an interview. So, all right, don't be too concerned. But if of course, everyone thinks, well, I'm just going in there to tell the truth. That's great. But for the most part, it is helpful to have a lawyer to prepare you so you can have it as smooth as possible, because I need to record a video about this, but we get a lot of calls and people tell the truth, but sometimes they don't even know what the truth it is themselves because they forgot when they met. Like sometimes a simple question like that can trip y'all up. And unfortunately, in some situations, USCIS does profile. I don't want to say racially profile, but they profile like interracial relationships, a country of nationality. So yeah. It happens. And when that happens, unfortunately, they separate people in the interview room. Okay, you wouldn't know that. So I'm not saying that would happen for you, message to the world, but just sharing for everyone else. You have to recognize when they wouldn't tell you right. They're not going to tell you in the interview notice like you're going to be separated in a different room. You would know that when you get there. Okay, when they call your name, then that's when they tell you, oh, we're going to interview so and so first, or you first. So that's hopefully that helps. So yeah, you wouldn't know that until you get there. But you would know best. Like if you think you sent in a shoddy package, or you hire like a notary and didn't do you don't think they did a proper filing, then, or just limited evidence, then that's when you definitely should speak to the lawyer. Okay. Hopefully that helps. Bishnu, sorry, Maria, I know I missed a couple other folks on TikTok. Bishnu, how to expedite I-730 interview. Waiting in Nepal, waiting for almost a year. My goodness. Unfortunately, if it's been a year, you have to file. One option is file a lawsuit, unless you send in a reasoning. I mean, everyone can have a lot of reasons, but typically to expedite, whether it's USCIS petition or with National Visa Center, it's maybe complications after birth or family emergency in terms of medical reasons, need treatment, things like that. But I think just saying, not saying like you're going to do this would say this, but if it's just saying, oh, it's been a long time and that's it, no, that's not going to cut it for expedite request. And it's discretionary. Some attorneys have asked me if we could file a lawsuit based on expedite request denied. I don't think that's a good use of anyone's money and time. If you're going to sue, then it'll be based on the delay itself of the entire case. Okay, Ice Queen, is your medical statement enough to request a work permit authorization? So yeah, generally they don't ask for like a paper document when you call in, but you want to be ready to provide evidence if they do ask. Sometimes they approve it, not on the spot, but they would email you without having to provide documentation. Sometimes they ask for us to fax in documentation, and sometimes they just outright deny it through email. So I don't know what your statement would say, but and people have a lot of different medical reasons. Unfortunately, not all of them, just because it's medical related, is going to be enough. Submit KD. No, you haven't received interview. You filed concurrently all the forms since 2021. Holy hell. You just got the work permit in January 23. Yeah, this is one for a lawsuit. That's 2 years. That's ridiculous. Sorry you've been waiting too long. Someone asked, Wayne asks, how do I deport my a-hole cousin? Stole your Xbox and Nintendo Switch. Man, that's a big deal, but man, I don't know. I don't think ICE is going to care about that part. Oh, you guys are funny. Okay. Xbox. This might show my age. I know I look slightly younger, but anyone heard of Game Gear? Anyone played that before, Game Gear? I don't think it lasted that long. That was in the 90s. Psycho Queen? I don't know if you meant Psycho Queen. If I applied I-130 for a husband and he decides to go out of country for work, do you have to reapply? Ooh. You don't have to reapply. I-130 is more about your family. I'm not family. Your marriage relationship, like legally married. So they check if you were divorced or not before, verify the timing depending on your state. But hopefully your husband did not overstay his visa before. Because if a person overstays their visa by 180 days, then it triggers when you step 1 foot outside America, it's going to trigger the 3-year bar. But if you stay more than 365 days overstayed and you step 1 foot out, it triggers a 10-year bar. So if it's your spouse and you're a U.S. citizen, they can file for a waiver 6018 after the petition approved. But yeah, hopefully you didn't have that situation. Your citizenship interview was canceled. Is that normal? I would say it's not common, but it does happen. And sometimes that's because if just depends on their schedule. And if yours was canceled, then there'd be several others that were canceled too. And so fortunately, in our experience, when it's been canceled, it's been fairly quick in terms of getting the next one. Okay. But if you miss it intentionally, for other folks, if you miss the interview intentionally, maybe because you're already scheduled to go out of town, which we had a client do that twice in a couple months, then you need to mail them a letter. Okay. Calling in, our homies, don't just call in because that's not going to be enough. The interview notice, the oath ceremony literally states on the bottom, I believe, or somewhere, you need to mail in the request because you need proof, right? Calling someone on the hotline, it's not going to be enough, unfortunately. Maybe they changed it, but every time someone's told me they try to do it by phone and someone says, yeah. On the USCIS side, yeah, it's in the system now. Yeah, that doesn't work like that. Okay. Trent, can I file for GC for your parents the minute I file for citizenship yourself? So no, it's not when you file for the N400. It's when you get your certificate of naturalization. Okay. So you can prepare it and everything, but you cannot file it until you become a U.S. citizen. All right. Sweet Sash. What about VAWA? What if my husband purposely doesn't file for your son that's living with you? That sounds like it's possible. Okay. We need to ask more questions. I don't want to, if it's VAWA related, I don't want to ask here on the live show. But yeah, we've had a case where a different one, slightly similar, but abandonment. They said they were going to do something and didn't, and just kind of like holding the carrot in front of them. It's really sad to hear, but yeah, that's a basis for VAWA. It has worked. Let's see here. Message to the world: if married to a U.S. citizen and overstayed visa, even though it's forgiven, what is a chance to travel with combo card and get back with any issues? Our clients have been able, and our clients in that scenario have been fine to get back. Anyone can travel outside. It's more about coming back in, right? So that's your question. I would say yes, you can travel as long as no arrests. Because I used to ask as long as no crimes, but really I prefer only people who have a completely clean record, no arrest. All right. Otherwise, honestly, just wait because green card cases these days based on marriage is fairly quicker than before 2023. So y'all can hold off on that next cruise for a little bit. It's the cruise line's always going to be there. All right, Lugo, what happens after I send evidence for knowing? So great question as well. On the USCIS case status online, they typically will say, okay, response received and under review. And so that's great. If you time it right and check your USPS mail or FedEx tracking number, then you can check the USCIS case status as well. But typically, depending on the NOID, what it was for, it may take at least a month because we sent in, someone hired us for a family hired us for RFE on a waiver, and that was pretty extensive. So I don't expect them to be too quick on that one. Benitez, why are you such about work visa? Can I contact you? Yeah, absolutely. Any scenario people have, we're happy to help. The only one that we don't help with is asylum. If you're seeking asylum, if you want to apply for asylum, we currently do not help with that. Okay, for new clients in that regard. But we do have a referral. If you're thinking about asylum, consider Brian Manning. You have to do your own due diligence, but you can. He has a TikTok channel and also on YouTube. Yeah, I mean, Anu says on YouTube, knowing means no hope. Some people can think that, but when people hire us in the middle of the case and we help with NOID, notice of intent deny, in my mind, when I train my team, I tell them like, look, this is the last leg for our clients. They need as much help as possible, really thinking outside the box, because I train them to say like, look, USCIS is telling us they're on track 99% that they're going to deny this case unless we can provide enough evidence that's relevant to answer their concerns. Okay. So yeah, we don't like to give false hope on people responding to NOID, but sometimes a NOID is not as crazy as some people may think. Sometimes NOID on silly things. It's kind of ridiculous. How long after petition should you expect to hear from NVC? I think you mean how long after I-130 petitions approved? About 3 to 5 weeks, you should receive an email. Okay, so make sure that you check your spam mailbox too. Unfortunately, there's nothing that you could just search online for. You just have to be ready in your email inbox, okay? Especially if you have like Gmail or something, it might go to your primary, spam, or promotions box. I don't know. You just got to check all of them. But also because that's the new way. The old way is they would physically mail the document, like a 2 or 3 page document. So they'll send you a PDF essentially with a case number, a new case number for a national visa and an invoice number so you can pay the fees. In total, it's 2 different fees, but total is $445. How long can you stay outside in Jamaica on a green card? In general, if you want to maintain, really thinking about 2 different ways. You have to maintain your status, and for the purpose of become a citizen. Okay, 6 months out of every calendar year does not have to be consecutive, but at the same time, you don't want the U.S. government to think that you abandon your status. So if you know you're going to be outside for more than 6 months, let's say even if you think, oh yeah, I plan to be 5 months, who the hell thought the pandemic was going to happen? So if you think 3 to 6 months you're going to be out, there's always potential you're going to be out longer. So just go ahead and apply for a re-entry permit 131 form. It's valid for 2 years. Okay. Hopefully it helps. Boy, I'm a bit longer than I anticipated. Shoot. So this is I'll stay on for another couple minutes. In the meantime, folks, if I'm not able to answer your question, please go ahead and give us a call. Don't be shy. The number is 720-740-4247. On Contact Us page. All right, so you can answer a few questions and you can actually self-schedule an appointment. We make it as easy as possible. All right, Marty MC, your petition 45 approved on Monday, and 765 still pending. Doesn't matter. Don't care about the 765 anymore. The next thing you're going to wait for is the green card in the mail. So check your 485 receipt number on the USCIS page pretty much every day. That's what we do for our clients when they get approved. We check every day so that because when it's the 485 application, they provide a tracking number. At least they're supposed to. It's not going to be tagged under the petition. All right, so check that out. Does CSPA apply to F4 category? Yeah, it can apply to that because, maybe your sibling has children. So yeah, I can apply any category in that sense. CSPA is annoying and frustrating. I get it. But it's not perfect, but at least it's there available. Okay, so speaking about CSPA, that's why I believe that's part of why USCIS does take longer for those petitions in general, because even if your petition is approved in 6 months for F4 category, it doesn't matter in the sense, generally speaking, because you're waiting for the visa to be available per the visa bulletin. So it actually, for the purpose of preventing age out, it's actually preserving it, locking in the age under 21. It's actually better if the petition's been pending longer, according to the mathematical formula. Okay, Hermie, can you bring your mom because you have a green card? No, you got to apply to become a U.S. citizen first. So hopefully you can do that first. Okay, and assuming you're over 21 as well. So then that would be considered immediate relative. Classification. All right, let's see. Well, this is amazing. There's seems like 99 more questions. I really appreciate it. Please, if you don't mind, folks, if you enjoy the way we share answers, content, pointing you in the right direction, please tap the screen on TikTok and click on the thumbs up on YouTube and Facebook. I greatly appreciate it. Apparently, it can share our profile to more people who have an immigration question. So greatly appreciate it. Let's see. I think the next person would be Grace. Oh, okay. I guessed wrong. Sam, how long does it take for fiance visa? So in general, people always ask, well, how long does it take for XYZ? And they think all the way to the end. But we're just talking about visa itself, then it's going to be at least probably 1.5 to 2 years. Okay. Because after fiance visa and that person comes to America, then within 90 days, you got to file for adjustment. It's a two-step process in terms of big picture level, higher level. Okay. Chrissy, if you're here legally, but someone is still threatening to call immigration authorities, what can you do? Well, if you have proof of non-immigrant status or any status, then you're fine. I mean, as long as you're able, if for some reason ICE takes it up and wants to go to where you live or work, then at least if you have proof of your visa, then it's fine. But I would think ICE would have some kind of system to check your status before they actually come out to waste their time. But if you're here on a non-immigrant visa and someone's threatening you, you might be able to apply for VAWA, okay? Or U visa if it's harassment or something like that, assault. So hopefully no one's touched you in that sense. No one's assaulted you. But if someone has that, and it doesn't have to be your significant other or your spouse. If it's just someone completely random, then you need to call the police. I mean, regardless, but that would be U visa. Regardless of who it is, you would need to call police. It's, of course, make sure you're safe. It has been 18 months since you filed K1 from USA to. Do you know time for it? No, I don't. I mean, yeah, it takes a hell of a long time, but I don't know what stage you're at. It sounds like you're still just fiance petition only. So the I-129F, if that's the case and your fiance petition is still pending, then you either need to file a lawsuit, mandamus lawsuit. That's what we help with as well. We help with that a lot. We sue the government almost every day. And then or refile your case as married. But you're already at 18 months, you're saying. So you need to give us a call, okay? Don't be shy. And we can, even if you don't know if it's reached what we call unreasonable timing, if you're thinking you're maybe a little too early, it's okay. Give us a call, talk with our CARES team members. They'll give you a better idea. I share like a chart with them so they have a better idea. We don't have a chart for every single scenario, but all right, check us out. Green card is expired. Do you renew it before I apply for citizenship, naturalization? So technically by USCIS policy manual, they say you have to have it renewed, but depending on the field office, some are more flexible, okay? Depending where you live, essentially. Or you don't have to do the I-90 and then N-400 because, yeah, we don't want to waste money. But at the end of the day, like I-90 freaking takes forever. I don't know why. That really, in my opinion, should be like rubber stamp. Like, why have to take so long to renew a green card? Okay, resident spouse PD 2020 applied for 45 with 245I. And you got RFE on July. Got, what was the last part? When approval. I don't know if your like visa bulletin was captured, locked in to be current at that time. But yeah, I mentioned this earlier. Generally, if you got RFE, did they ask you if you maintain your status or provide proof of maintaining status? If they did, then that's the concern they have, is that you failed to maintain status. So that's the main issue, even with 245I, because only 245I only covers the part about the legal entry or illegal entry. But so if your spouse can become a U.S. citizen, that would honestly be better. So that can automatically waive the unlawful presence. Would you get a letter to tell? So one of the thing, I think your name was User, but in that situation, if someone had already filed a petition based on a resident spouse, and I would probably ask USCIS to admin close that 45 until your spouse becomes a citizen. So then you can allow time for your spouse to become a citizen, or wait for your spouse to even be eligible, because maybe it's too early. Okay, would you get a letter to tell you where to do the medical no from NVC? So travel.state.gov website does, if you pick on the section that says like reciprocity, depending on the country, each country has like their own list of medical clinics. So it's usually very, very limited, like maybe 2 or 3 different clinics for each consulate or embassy. But no, they're not going to tell you. You have to go find that information. So that's why a lawyer is helpful. A legal team. Patty Brink, your husband got his 10-year card last year. Congratulations. Will he have to stop renewing it? No, he's going to have to renew it every 10 years unless he becomes a U.S. citizen. Then he's done. Once you become a U.S. citizen, then you don't have to file any more documentation, paperwork. Okay, so even though you got a 10-year card last year, you don't have to wait the full 10 years to apply, right? Like, so if you got the green card through you, Patty, then once reaches 3 years, then he can apply at 400 within that after 3 years. Well, technically 90-day period before 3 years. Okay, hopefully that answers your question. Okay, folks. I got one last question I can answer. I really appreciate all the questions. I really, really appreciate it. If you don't mind, please give us a call. Send us a DM message or go to our website, greencardguys.com, answer a few questions. Then you can self-schedule appointment, okay? But not everyone is qualified for free 15 minutes, so I don't want to mislead everyone. Our team does need to verify a situation we can offer the free 15 minutes. It's just we have limited time in the day, and sometimes I don't anticipate going live a long time. So thank you for all the questions. Humair, is fiance K1 taking longer than spouse? Yes. That's my short answer. So you can get married remotely, especially for folks that have not started the process, filed any application. But even if you have, you can get married remotely through Utah County, state of Utah. As far as I know, they still allow marriages remotely. So might as well take advantage of it, okay? Because it's helped a lot of our clients and our colleagues, friends, clients, okay? Okay, fine. One more question, Maria. No more pin comments after this. 21. Okay, so Stardust, 21 years and 3 American-born kids. Oh, they're 21 years old. And can you file for AOS? They can file. So 21 years old. That's great. Only one needs to file for you. Congratulations, by the way. You waited this long. Had to wait this long. And you're on top of it. So yes, the age, you're on point on that one. Now we just have to make sure, do you have legal entry? If you don't have legal entry, that could be okay in terms of the purpose of getting residency and staying in the United States for the entire process. If you don't have legal entry, then there is several exceptions, but the main one, if you have a U.S. citizen adult child applying for you, then is 245I. Maybe you had a sibling or another family member file for a petition for you before April 30th, 2001. Okay, that was a cutoff for 245I. So hopefully that helps. Okay. All right, I am done. Sorry, I got to go to another team meeting. I got to grab a bite to eat. So I greatly appreciate it. Thank you so much for the questions. And today's Wednesday. I will see y'all tomorrow. Give us a call. Don't be shy. See ya.